There's something in your past that's not pretty. There's something that you know is going to come out during the course of trial. What can we do as the plaintiff's attorney, as the attorney who represents the injured victim, do at trial to minimize the effect of what happened to you in the past is not going to destroy your case or your credibility? You want to know the answer? Come join me as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law in the state of New York. So now something bad happened to you, and now you know that if the jury finds out about it, it could destroy your credibility. And the defense knows about it, and he's going to do everything possible to tell the jury about it. So what's the one thing that I can do to take away the defense's thunder? The answer is, I tell the jury first. I'm going to tell the jury during jury selection that there's something in your past that we have to talk about. I'm going to tell the jury on opening remarks that there's something that happened to you that you did in the past that's really, really bad, and that I have to get out and tell them about. And you know what? I'm going to be the first one to tell them about it. I don't care how bad it is. I don't care how horrible it is. I'm going to be the first one to do it. You want to know why? It's because I want to steal the defense's thunder. I want to take away that surprise element, because imagine if I didn't even mention this thing that was so bad in your past. And now the defense attorney gets up to make his opening remarks. He turns to the jury and says, there's something that Oginski didn't tell you about. Did you hear him say one word about his history? Did you hear him say one word about this or this? And now, if he were to do that, now our credibility is destroyed. Everything that we strive for during the course of trial is to build up credibility, to show all of the facts are supported by the evidence in our case, by the testimony in our case. If I hide from the fact that you had something bad happen and don't even mention it during the course of the beginning part of the trial, it's going to come back to bite us on the butt. It's going to be terrible, because the defense attorney will take advantage of that. He's going to show that we are out to hide something, even though it has absolutely nothing to do with the claims that you're making in this case, whether it's an accident case or a medical malpractice case or even wrongful death case. That's why you'll find that really smart attorneys who now have to deal with some issue that went on in your past history that is troublesome and bothersome and maybe morally repugnant, maybe awful, maybe terrible to talk about. The fact is, we have to address it first. We have to minimize it. And then I have to show to the jury that what happened to you in the past has absolutely nothing to do with the claims that are being made today. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in these civil lawsuits here in the state of New York. You know, I recognize you've got questions or concerns about your own particular matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit and you've got questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, @ oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.